You know, some of you ask what it's like to work at KSB on a daily basis. Just go read that St. Louis case. You'll have a good idea of what it's like to be here at KSB.
That's what it's like to work with Steve, not necessarily at KSB.
IEP meetings. I love IEP meetings. Usually when you guys bring us in, we're having a lot of fun at that point. I was lucky enough to represent parents in juvenile court for 13 years or so. I was able to attend IEP meetings on their behalf. So I've sat in that chair and then obviously sitting representing schools. So they're a lot of fun as far as I'm concerned. I know you guys don't always agree, but all right. So we have to have periodic reviews of the IEPs and basically they're annual reviews at a minimum, but you have to have an IEP in place prior to the beginning of the school year or before you begin services, obviously. And again, there's a periodic review, but no less than annually to determine whether the goals are being achieved. 364 days per month. So when we say annually, what are we talking about? The meeting's not the effective date of the IEP. Really, we're looking at the date we sat down and reviewed it, and that's where we're counting the 1 year from. And so the key action is the meeting itself, not when you're starting the services. So always look at that meeting date to determine whether we're in that annual time period. As you can see there, that annual meeting will creep, right? Because you need to hold it within a year. Well, we're going to keep scheduling it a week sooner, 2 weeks sooner. And so some that were at the beginning of the school year may creep into the previous school year. So instead of meeting in August or September, you might be meeting in May. So you do have to plan ahead of that, put some ticklers on the calendar to make sure we're not missing any of those deadlines. Preparation. You know, we were at the Tri-State last week, and I heard it again and again, and I saw it in sessions, heard comments with some of the people I was sitting next to. They're all worried about predetermination. They freak out about it, and I don't know what it is we did or what they've done nationally to freak you guys out about what you can and can't do. No, you don't want to come in with a closed mind and a set in stone plan, but you can have meetings, you can prepare reports, you can do a whole bunch of things in preparation for a meeting. That's not predetermination. You should have research, you should have draft documents, you should be sharing information with everybody prior to a meeting. So don't freak out and think you're predetermining just because you're preparing for a meeting.
You knew I was going to have to interrupt. Just real quickly on that, I think Steve is exactly right. Everybody's freaked out about predetermination. The other thing we consistently hear from attorneys that represent families is, why does everybody have a draft copy of the IEP but the parent? And I think schools are afraid to share that draft IEP for predetermination purposes. But I would ask you, if you are a special ed parent and everybody has like a hymnal to sing out of except you, that feels more like predetermination to me than if we provide everybody with a draft copy. And I have a meeting with a special ed attorney at an IEP meeting coming up on the 25th of November, and he said, can you just send the plan so we don't have to talk about all that present levels and all that stupid razzmatazz that the teachers always want to talk about? And I'm like, Mr. Attorney, the teachers don't want to talk about it. They think you want us to talk about it. He's like, no, I don't care. Let's just get to the stuff we're fighting about. So I guess what I'm saying is sending out the draft document and seeing what the family wants to do in terms of focusing the meeting can really help you with your preparation.
Absolutely. And just slap draft all over the stuff so that they understand that's exactly what it is. So what should we do to prepare for meetings? Obviously, have the staff communicate, get together, talk about things prior to the meeting to make sure we're ready, review those notes and new evaluations with staff and parents in advance. That's what Karen was saying. You don't want to read a 20-page report at the meeting, right? You don't want to see it for the first time there. Let everybody get it as far in advance as you can and let it soak in. Discuss behaviors that are of concern with building administrators. The parent should be provided a copy again of the evaluation report. Explain the context. I mean, you guys know you've got parents that run the gamut in terms of sophistication. And so be prepared to explain it, hopefully in lay person terms, so that they know what the heck your report says with all those fancy terms and all those acronyms and all that stuff that's in there. Consider how other evaluative data compares and contrasts with your own. So they are going to bring additional information. A lot of parents do, a lot of their attorneys do. You do need to take that into account. You do need to compare that to what you have. Sometimes it does show some holes in our information or some gaps in our information. So make sure we take that into account. And be prepared to discuss how those various placements and services could be implemented. That seems to be a big bugaboo when we get involved in some of these cases. It's what services are going to be provided and how are you going to do it, who's going to do it, and they get all whipped up about that. So always be prepared to discuss that. If you're not keeping minutes of your meetings, handwritten minutes or typed minutes, you absolutely should be doing that. We prefer you have a separate note taker, somebody who can focus solely on that part of it and not have to try to say, what did you say, missing missing participating in the meeting because they're trying to take notes, or not taking notes because they're participating in the meeting. So if you can have a separate person do that, that'd be great. Make sure they're clear, complete, and extensive. I can't tell you, when it turns into a dispute, it's usually a year or two later. We find these minutes invaluable. They're probably the most useful information that we have, because it clearly, it's contemporaneous and it shows us exactly what the big issues were because they're right there in the minutes. Even if you're taping it, take them down. We've seen the meetings where everybody thought it was being taped and lo and behold, it wasn't. Or later on, those recordings get misplaced, or they're digitally recorded and they get erased, things like that. So make sure you're kind of doing double duty there. Do reread them and correct them. Let's make sure they're accurate at the time, because you'll see at the bottom, don't alter after the fact. The reason that you'd be amazed at how much weight these kinds of documents have when they're created at the time. But if you go back in and admit, yeah, 6 months later, I realized I screwed that up, so I went in and changed it. Now the question becomes, well, how accurate were they at the time? And what else did you change? So everything that you've created that gives you all that weight kind of disappears. We prefer to have everybody sign them who attends them. Again, as I said, it could be a year or two later when we're redoing these. And somebody say, I was never there. I don't know why you listed me there. But if you've got their signature on there, that shows they were there at some point in time. And so there won't be any dispute on that. Mandatory.
Sorry, one more. I'm sorry. Over and over again, we have a parent say, no, the speech path was not there. You just wrote her name down. No, the score or the psych says, God, I do so many IEP meetings. I can't remember if I was at that one or not. So this seems like an anal retentive thing. It comes up all the time where there's a dispute about whether someone was actually there or not. It's worth the effort.
Okay. All right, mandatory participants. You all probably know this, but we've got the parents, and we'll go to this one with the red slide. Parents are often, like I said, I represented parents. I know how spotty their attendance can be at these meetings. They oftentimes have their own issues that they're dealing with, and find it difficult to attend the meetings, but they have to be there. And so we have to make legitimate efforts and repeated efforts to make sure they're at those meetings. Regular education teachers, we have that highlighted. We have some teachers who think, well, as long as I made an appearance, I can leave. That's not how it works. Now you could have them tag in and out. You just need a single regular education teacher there at every single second of the meeting. And so if you want to use 3 different teachers, you absolutely could.
I think it has to be the same one gen ed teacher.
I think so. See, I've read the cases that say you can tag in and out. So I guess it depends how many regular ed teachers. If you're a middle school kid and you have 6 regular ed teachers, I think you could do that. If you're an elementary kid, obviously you probably only have 1. That's not going to work so well. The representative of the public agency, sometimes we get questions about who is that? Who could that? Can they spend your money? If somebody asks for a service at that meeting and you say, I don't know, I'm going to have to ask Bob, then Bob probably should be at that meeting. You're not a representative of the public agency if you can't find them. And so we need somebody with that kind of authority. Other individuals who have knowledge or expertise, and that's at the parents or the school's discretion. We get this question all the time. Mom wants to bring grandma. She's a pain in the ass. We don't want her here. Our response, to be blunt, is too bad, grandma's coming. If the parents want them there, we let them there, at least once. Now, if they disturb the meeting or cause chaos or do something else that's inappropriate, we deal with it at that time. But basically, if a parent wants to bring anybody, we generally say, yeah, let them in. And as long as they're appropriate, we'll do that. And then obviously, if it's appropriate, we always include the kid in the meeting. Excusing team members. You can excuse team members. It always has to be in writing. And there's 2 different situations. One, it's because that person's not needed. They don't really have anything to discuss or modify or contribute to the meeting. They still have to be dismissed in writing. The other is, even if they do have something to contribute, they need to be excused by the parent in writing, and then that person just submits their information in writing so that the team can consider that. And obviously, if you know they're not going to be there, the sooner, again, you distribute that information, the better. And it includes excusal in whole or in part. If you're going to be gone for a minute, technically you need to have an excusal in writing. You can't just have those mandatory participants come and go. Parent participation. So obviously the special ed laws guarantee parents the right to participate. So what does that mean? They get notice of the meetings and they get to be part of the identification, evaluation, and educational placement of the child and the provision of FAPE to the child.
Real quick, something to add. I just had this question twice last week. So the parent gets to participate. Agreed. To what extent does the parent get to participate and harass our staff members outside of the meeting? The short answer is the regulations make very clear that the parent's right to advocate. There are First Amendment implications with that. They've got a right to be strong advocates. Their right to participate, though, is in the meeting. We've got a specific section of the regulations that says that does not necessarily include discussions outside of the meeting on issues like the appropriateness of curriculum for that child and those sorts of things. Basically, if they've got a qualm with how you're doing it, they're required to bring it up in a meeting. They don't get unfettered access to tell you how crappy your teachers are. So if you have teachers that feel like they're being harassed by parents, you should empower them by using that regulation and re-clarify and reestablish the appropriateness of that parental input in the meeting. Be careful not to say we're not going to listen to you outside of the meeting, but understanding when we're talking about the services and related services for the kid, that's not unfettered right to email your staff whenever they want to.
And generally, their right to access and their rights outside of a meeting, it's the equivalent of a parent of a general education student. They don't get special rights outside of the ones that are provided under special ed laws. Parent participation. The basic piece to take from this is their participation has to be meaningful, or at least they have to have a meaningful opportunity to participate. And so you have to consider their suggestions and you have to incorporate them if they're appropriate. So it means you have to listen. It means you have to consider. It doesn't mean you have to nod your head and adopt everything they do. A way not to do it is the deal case. This was an ABA therapy case. And we've heard this over the years. So I think we've gotten better. There's less and less of it. But you can't say we don't do that. We can't afford that. Oh no, the superintendent doesn't support that program. And part of what came down here, that was the deal case. They said all of that and more. They had adopted this TEACH program, which cost them a whole bunch of money. And they basically said, that's what we use for everybody. We paid $1 million for it. And so that's what we're using. You can't do that. That takes the I out of the IEP. You are required to make sure it's individualized. And so if there may be a case where ABA is appropriate for a child, so you cannot just say, no, we don't do that. That takes away their meaningful participation opportunity. Independent education evaluations, you absolutely have to consider those. You should consider those. But you should look at them, obviously, and ask some questions about them. Again, you have to consider them, but you don't necessarily have to incorporate them. So you need to know what did that person, that independent evaluator, what information did they use to create that evaluation? Did they even meet the kid? We've had due process hearings where it's shocking to us. Did you ever meet this child? No. Well, how much weight is a hearing officer going to give that kind of evaluation? Not much. That's about how much you should give it. Did you see their IEP? Are you aware of their program? Did you observe the kid in school? Did you only get information from the parents? You want to do some basic questioning about the content of those IEEs to see, are they really worth anything? And sometimes they are. Sometimes they're fantastic. Other times they're basically worthless. So, but we need to ask those questions to make that determination. Discuss placement options. I think we always should be doing that. Run the gamut. If the parent has questions about a couple of different things you're looking at, you should explain it truthfully, honestly, very, very transparently, and answer any parent questions. I think when we get called in, quite honestly, half the time, at least, it's a breakdown in communication. And I think if we just had better communication from the outset, we may not have some of the problems we have. Like I said, some of these parents have no idea what the rules are, just no clue whatsoever. And so they need those questions answered. And the better we answer those, I think the fewer problems we're going to have in the long run. And they know you're shooting straight. So who are these parents anyway? There's a lot of different parents under special ed. It's not just a biological or adoptive parent, but obviously they're the first one. Foster parents are parents. And I dealt with them, like I said, at the meetings I went to. A lot of times foster parents were there. We get into a fun little battle when you get the bio parent and the foster parent showing up, and you've got a foster parent who is gung-ho that they're going to adopt that child, and that's their child. And so we can get a little battle going on at some of these meetings. Guardian, and that can be a legal guardian. under the law. It could be somebody, as you'll see below, just somebody who's taking care of the kid. But we want to make clear the guardian can never be the state if the child's a ward of the state. So the caseworker cannot be the guardian. They cannot be a parent under special ed laws. No matter what they tell you, they cannot do it. And then we've got the last one, as I said, that's kind of the in loco parentis person. They may or may not be a relative, but it's somebody who's legally responsible. They've taken in this child for whatever reason and don't necessarily have any legal documentation to support it, but they are taking care of that kid. So any of those people can be a parent, and in some cases, you could have 3 of those people at a meeting. Biological or adoptive parents, there's 2 caveats to this parent definition. There is a presumption in favor of biological or adoptive parents, and this was the issue I was alluding to earlier. When you've got parents who are involved in the juvenile court system and the kids are placed outside of the home, a lot of times either HHS or the foster parent tries to, I guess, take over, is how I would say it, and try to exert their will over that of the parent. But if the parent still has legal authority in that the court has not limited their educational rights in any way, either limited them or extinguished them, and the person is attempting to act as a parent, and I would argue, heck, if they're at the meeting, they're trying to act as a parent, they get preference over anybody else that's at the meeting. So if you have those multiple parents at the meeting, that bio parent wins. Now, what are the exceptions? If the court orders someone else to act as a parent. So again, and it's rare, but it does happen. A parent, biological parent, is not acting in the best interest of the kid, at least as far as the court is concerned. They can appoint an educational surrogate. They can give educational rights to the foster parent. They can give educational rights to anybody they want. If there's an order like that in place, even if the biological parent is present at a meeting, that person in that court order trumps what the biological parent wants. Surrogate parents. This one to me is easy. If any of these people are present or exist, you don't have one of these. You don't have a surrogate parent. And we still run into this occasionally where schools will say, well, we can't get a hold of the parent, or they haven't appeared in a while, and they want to appoint a surrogate. That's not the way it works. So we have to have a situation where a parent cannot be identified. Parent cannot be located. If the child is a ward of the state, in some instances, we might have to appoint a surrogate. And if the child is an unaccompanied homeless youth, you may have to appoint a surrogate. But those are the limited instances where you would do that. And in most cases, frankly, where we've had people try to appoint a surrogate, it was not an appropriate situation to do so. And here's an example of how far it goes. In the Garvey case, they had a legal guardian, and the guardian got called into work and couldn't make the meeting. And they said, hey, do you mind? The school called and said, do you mind if we appoint a surrogate? He goes, oh, no, go ahead. That's fine by me. And they did that. Well, then later the guardian didn't like the decisions that were made at the meeting and challenged it. And the district said, or the court said, or hearing officer said, you're not allowed to appoint that surrogate if there is a parent involved. If that person's in the mix, you cannot appoint a surrogate. And even though that person gave consent that had the legal authority, that doesn't somehow make that change in any way. What if the parent is being a jerk? And that's quite often when we get involved. You can't appoint a surrogate just because we're not getting along. And in this letter to parent, it says uncooperative. Essentially what they did is they said, well, you know, the parents weren't very responsive in the past, and they haven't been very helpful or cooperative with us when they did show up. So we went ahead and appointed a surrogate. They didn't even try to make appropriate contact. I think they tried once, but essentially if you make one attempt to contact them and they don't respond, you need to email, call, even visit in person before we're going to go down a surrogate appointment type role. You really have to make significant efforts under the rules before you can start looking at appointing a surrogate. This next one, this is an interesting one. As I said, the juvenile court, they have the authority. Yes, ma'am.
Question.
Yes.
If the foster parent is in attendance and bio parent is not, but bio parent still has educational rights, can the meeting be held with just the foster parent?
Potentially, yes. I would look at what efforts have you made to get that biological parent there? Because again, if the biological parent still maintains educational rights, that's still person number one on the totem pole. So if you made one attempt to schedule a meeting, they don't show, I wouldn't go forward with the meeting. I don't think that's a parent in that instance.
I think if we've tried.
Yes. I mean, if we've made 3 attempts, 4 attempts, and the biological parent simply isn't attending, which again, I had with a lot of my clients, at that point, I think, yes, you can move forward. But if it's the first time, I wouldn't move forward. If it's the third or fourth or fifth time, absolutely, I think you can go forward. Just document the heck out of the efforts you've made.
Did I understand correctly that if there is a foster parent involved, you do not have to appoint a surrogate parent?
You understood 100% correctly. If there is a foster parent involved, you cannot appoint a surrogate. And so you should be looking to that foster parent to act as the parent or one of the other people that's on the parent list. But on this last one, a juvenile court can appoint an educational surrogate if they wish to do so. And that happens. It's pretty rare. But if a parent simply is not doing what's in the child's best interest educationally, they can and will and do appoint educational surrogates. Hearing officers don't have that authority. As far as I'm concerned, they don't have that authority. Schools certainly don't have that authority. You can't do it just because they're making horrible decisions. That's their right as a parent, unless and until a court says otherwise. The other adults, we've talked about these. Those are the ones, the foster parents. Those were very common in the cases I was involved with when attending at Lincoln Public Schools meetings. The guardians, and then the in loco parentis. That in loco parentis, it often is grandma, it's an aunt, it's a brother. It doesn't have to be. It could be a non-relative. It could be anybody, frankly.
Can it be a boyfriend?
It could be a boyfriend. It's happened where the boyfriend is of age and the kid is not. It makes for a weird dynamic, but legally, yeah, it's certainly possible. A 20-year-old boyfriend can be a guardian for or an individual acting in the place of a bio parent for a 17-year-old kid. So it happens every once in a while. Parent participation decisions. Essentially, the message you should get here is we're not going to exclude parents for our own reasons, for our own benefit. It's got to be for legitimate reasons. So in the Hawaii case, that Doug C. versus Hawaii case, they requested to reschedule due to an illness, and the school said, forget it, we're going for it. And you had a little bit of history there. You had a family that wasn't attending very consistently. They were a pain in the butt to get them to meetings. And finally, after years, the school just kind of said, that's enough. We're just going to go forward. But they'd only tried one time in that instance. And the court said, no, you can't do that. And they said, well, wait a minute. Our annual review is due. I mean, we're going to be violating federal law if we don't have this review. We said earlier, it's every 1 year you got to review this. Our date's going to come and go. Court said, too bad. Basically, you're going to have to balance those two competing interests. And they said, if we're on the first time, the competing interest clearly goes in favor of the parents. And so that the fact that you're going to run over that deadline doesn't matter. The Toledo case, they were asking to reschedule. In this one, we had some very uncooperative parents throughout, again, historically, but they had asked to reschedule once. That was not refusal to attend. And in this case, the school said, now, wait a minute. We've made several attempts. We have 13 school personnel members that need to attend this meeting. You don't understand what it's like to try to get their schedules to go together and have this meeting. And the court said, we don't care. And so that's not going to be a reason to justify excluding parents. The TS versus Weiss case, the repeating rescheduling can constitute refusal. I thought this one was a little harsh on the parents. They rescheduled twice. One time they said, hey, we have an evaluation scheduled for our kid. And that was in July, early July. And then in early August, they said, well, now he's on new meds. We want those to stabilize before we do any more evaluations. The court said, oh, nope, good enough. And so, sometimes you never know. If you'd called and asked me, I would have said, no way, we have to make further efforts. But there the court said, no, we don't. The Joliet case, BH versus Joliet. In this one, we had a parent who absolutely refused to come between the hours of 9 and 5. Always wanted a 6:30 p.m. meeting. And the school said, no, we don't. It was interesting. They said, we have a blanket approach. We never meet after hours. It's got to be during the school day or we won't do it. And the court said, that's allowed. They said there is no rule in the special ed laws or regulations that say you have to hold this after hours at the parent's convenience. I don't know that I would push that hard depending on their schedule, but typically parents are able to get some time off or at least have it early in the day or later in the day. So. Oh, yeah, there was a new ruling from the Department of Labor under the Family Medical Leave Act. They said you could use the Family Medical Leave Act if the child has some medical issues, and it would be appropriate and necessary for the child or for the parent to attend that meeting. a parent actually could use FMLA leave to attend these meetings. So that's kind of a new nugget we could use if parents say, oh, I can't get time off. That's something they could explore and should be able to attend at any time during the day. MC case, yeah, this was a case where you don't do what this school did. So we had a special ed kid, and so we have the IEP meeting, and they draft the meeting. They said we're going to give them 240 minutes of TBI services per month. Parent agrees, says that's great, that's fantastic, signs off on it. A week later, the district goes, oh no, that was supposed to be 240 minutes per week, not per month. So they went and changed it. And even worse, they never told the parent in any way, shape, or form. They never sent them didn't give them a copy of the revised IEP, didn't send them a note, didn't send them a letter, no email, nothing. Just did it. And then the parents didn't find out until they actually went to due process on different issues. And the attorney discovered this. And did the school's attorney turn it over? No. They tried to bury it in all this paperwork and didn't. It killed them in front of the court, in front of the hearing officer, in front of the court. They said, this is not how we operate. You don't hide stuff from people. And they chastised both the school personnel and the attorneys, saying that, no, that's not going to fly. So to the extent there was a legitimate issue that the school could have defended, it pretty much was gone at that point in time because of the behavior of everybody involved. And so if you need to make that change, contact the parent and say, hey, we screwed up. If they agree, you can do it in writing. If they don't, you need to convene another IEP meeting to discuss those issues. Yeah, and here, I don't love this, but essentially you're saying an IEP is like a contract and you can't change it unilaterally. But you can see right there, a unilateral amendment is a per se procedural violation, and it's going to violate their right to participate. I mean, think about it. You could completely and totally undermine everything that was agreed to at the meeting by simply changing it after the fact. So that's not going to fly. And so you do need to, in your mind, treat it like a contract. This is what we promised to do, and it's your safe harbor. You can't go wrong by following this. So at the end of the meeting, verify if there's an agreement or if there's not an agreement. If there's not, you simply slide across a copy of the parental rights and move forward. Get them a copy of that finalized IEP. There's no need to beat around the bush or stay there for 5 hours trying to get to an agreement. If that's what the team's consensus is, then that's what the plan is, and the parents get their rights if they're not happy. Do not give in if the request is educationally inappropriate. We do see this a lot, and I get it. We've all been in marathon meetings where you're thinking, God, if we just give them that one thing. But it's not right, because take it to the extreme. You are at a hearing. You're at a due process hearing. Number one, more times than not, when you give in, when you don't think it's appropriate, it doesn't work. And number two, that means you're going to head to due process anyway. And then I put you on the stand. Did you give them this counseling? Yeah. Did you think that was appropriate? No. Well, so you're under oath and you have to truthfully say you were giving him something that you didn't think would provide faith. Don't do it. It'll bite you in the butt. I do include a statement somewhere that says the IET met on January 1st and the plan will commence on January 7th. That way, number one, there's no gap in services, but two, there's no question as to when this started, when it stopped, and it gives everybody time to consider, is this going to be appropriate? It gives the parent time to go and object over at NDE if they're not happy with things. So with that, I think we are done with that, and we're going to talk about drafting IEPs and VIPs.
So I got a couple questions on the mental health aspect while Steve got rolling, so I'm going to answer those. And then we're kind of debating here, thinking about maybe a 5-minute break just to refill coffee, not a full-blown call and see how things are going in the building break, but just a quick 5-minute break and we'll get started again. So, but before we do that, let me answer these questions that came in. I'm just seeing here. What are our rights if parents don't support testing? This is a really interesting question. If the child is not yet identified as a student with a disability, we do not have the ability to sue and force parents to agree to give that student special education services. But if the student is enrolled in a public school, we can initiate due process and ask a hearing officer to order testing without parental consent. Now, the question about why we would do that if we can't serve the kid, even if he or she verifies, is a whole nother question. But we can, but only if the student's in a public school, not in a private school. Did you want to?
There's more questions.
Okay. So if that happens, call us. Now, if what we're talking about is like a triennial or the student already has an IEP, The legal analysis is a little bit different, but we can theoretically force a parent, get a hearing officer to order an evaluation, but we can't force a parent to accept special ed services. And that was a change in 2006, so sometimes you still see old training materials or old things that talk about the fact that we could get due process and get a kid on an IEP, and that's not true anymore. It's only to get an evaluation. In regards to our students with mental health issues, should students have an IEP instead of a 504? How will schools handle this with an increase in mental health issues? I'm not sure. Every child with a mental health issue should not have an IEP.
They need special ed related services.
It's only if they are in need of special education and related services. I would use the analogy of the asthma situation or diabetes or some of the other physical impairments that we've kind of worked our way through over the years. A child with asthma that is well controlled with an inhaler and we only need to be aware of him during allergy season is 504. A child that has frequent life-threatening asthma attacks needs an IEP. So that level of degree is a decision that you guys have to make, and you do that through the 504 committee and the MDT. I would do exactly the same thing with mental health. So some students with mental health issues, it would be wildly appropriate to have a 504. Some students with mental health issues, they clearly need an IEP. So that's gonna be driven by the facts of the situation. Student who is suicidal, depressed, and cutting, she's under medical treatment. Do we need to be following up with an IEP or a 504 plan? Yeah, I would. I would 100% convene the 504 committee at a minimum and talk about whether she has a physical or mental impairment that substantially limits a major life activity. I probably would also run this student through the MDT. Now, it's possible that it doesn't have an adverse educational impact and she's not in need of special education services. So she may not verify under IDEA, but I would 100% give this girl a 504 plan if the facts are, if I knew nothing else, I'd be like, holy shnikes, at a minimum, we need to talk about whether it substantially limits her. So yes, you should do something with that kid. Off topic, this is an interesting question. Question is, we've been told sometimes by NDE that to do OHI, you have to have a diagnosis from a medical provider. And sometimes we've been told that we can't require a diagnosis unless the district is gonna pay for the evaluation going forward. It is true that OHI requires the student to have some medical condition. However, there are a lot of cases that say the school cannot just sit idly by and say, well, mom, you didn't get us a diagnosis. You know, obviously he's bleeding from the ears every day, but we're not going to do anything until you get a doctor's note. We can't just sit by and blame the parents for not getting the kid to the doctor. Under those circumstances, we are obligated, number one, to fund the doctor, or two, you can verify on data and report, right? Especially with mental health. Go back to the ED where it says that we can diagnose or we can verify based on the student's inappropriate behaviors and depressive episodes. We can't diagnose depression, but based on data collection, we could verify a kid ED based on our data reports and call it depression. You see what I'm saying? But I would be real careful about saying to the family, sorry, no IEP for you unless you pay your copay, because there's a lot of families that for whom that would be prohibitive and they can't get an IEP then. And now we're in the business of paying their copay, and that's not where I want to be. So you can identify as OHI without a medical diagnosis if you've done data collection correctly. Call your lawyer to make sure we've checked all the boxes.
All right, what is the standard for determining the appropriateness of students' attendance at an IEP meeting?
It's supposed to be in the judgment of the educational team. I'm assuming the student is 16 years old or older. Do you want to jump on that, or I just realized that's yours, not mine?
Well, and in juvenile court, I did attend as guardian ad litem for some kids. And I had kids who would be 12, 13 and would say, I want to attend the meeting. We never had an issue with somebody saying, no, we don't want them here. There would be times where certain issues would not be discussed in the presence of the child, usually mental health issues. But I guess I've never had it, and I would look to the team to decide whether they want that information or they think it's appropriate. But if a child is expressing they want to be there, I would allow them to be there. And then I would look to the issues we're actually going to discuss in their presence. If there's some issues that are not appropriate for the kid, then obviously don't discuss them while that child is there. But I've had meetings where the kid went in and out of the meeting because certain things came up and we had to talk about it. So
now, after the kid turns 16, we need to have the kid there. They're a mandatory participant for transition purposes.
The IEP meeting before they turn 16.
Yeah, that's right.
They
That's
have
right.
to be invited.
That's right.
The transition context is just different, obviously. There are cases out there that say, even if you invite a kid to the transition planning IEP meeting, parents don't bring the kid because they're going to yell at you and don't want their kids to see what jerks they are.
Yeah.
You are still required to get that kid's input somehow.
Yes, that's right.
So understand that it's just a different set of rules for that transition meeting.
Mom doesn't want dad or child at the meeting. Dad wants to attend. Must we have 2 separate meetings? No.
Hell to
you
the
don't.
no.
I will tell you, the one exception that I look to is that there was a significant physical domestic abuse that had occurred in the past. I would encourage schools to at least consider it. Short of that, just because they don't get along.
But
no.
having 2 meetings, if you have 2 meetings with one with the abuser and one with the victim, which is the IEP meeting.
Exactly. I mean, you get into that issue. What we've done is had whoever the abuser was or whoever the problem child is gets placed in another room on the phone.
Yes.
We've done that. And so do we accommodate sometimes? Yes, but it's not ideal. But bottom line is, if you don't think it's necessary, you absolutely don't have to do it. No. I've never run into the issue where a parent did not want a child at the meeting, but the child wanted to be there. I think that would be fascinating because it says the child can be there if appropriate. Who determines if it's appropriate? Obviously, I'm biased. I represent schools. I would say it's the school's meeting. Let's face it. If there's a violation, who gets in trouble? Not the parents, the school gets in trouble. So I think you get to determine if it's appropriate for that child to be there because later it could be raised as an issue. You didn't have the child included and you should have included the child because it was appropriate. And you would testify, yeah, I thought it was appropriate. We didn't do it because mom didn't want it. So I would defer to the school officials' decision on whether if it's appropriate or not for the child to be there.
But again, if it's transition, we have to get the input from the kid in some other format.
One question from the chat. If an MDT is held and parents want to think about it, later review services, does a full IEP meeting still need to be held?
So we've done MDT freestanding. We say to the family, she verifies whatever, OHI, ED, and mom and dad say, okay, but we don't know if we're going to accept special ed services. We want to think about it. Jesus God, I think I do the full IEP because I want to prove that we offered a free and appropriate public education. I think you should probably still do the whole IEP.
You're going to need,
and
here's your
offer it.
notice of opt-out if
Yep.
you want to give it to us before the meeting.
That's right. That's right. That's right. That's right. I have one more. Karen, one of my teachers came back from a training last week with you and said we should be giving all our kids a 504 screener. Is this correct? I know exactly what that person is referring to. In my mental health deck at the Tri-State, I had an example of, the pyramid they have for the multi-tiered system of supports. And it was using an MTSS approach to mental health. So there are some school districts, and in fact, there are service units in the state that have implemented an MTSS approach to mental health. And so they're giving mental health screeners to like all 4th graders, all 7th graders at places in the student's progression through their academic career where data shows that students typically begin to present mental health issues if they struggle with that. That is not required. It is one approach. I think it's an interesting approach, and I actually, just knowing what I know about the mental health statistics, I think it might be good public policy, but that is not legally required. And Julie, if you want a copy of that screen that just show the little triangle that I had on the deck, shoot me a text back to this text and I'll send you a screenshot of that slide so you can see what that looked like. But hear me, I am not saying you are legally required to do a screener for all students. I'm saying that is one option that some educational entities are implementing, and I think it is interesting and has some positive things about it, but I'm not saying you have to do it.
Okay, 10:08. We will be back at 10:13.